think we're live, Sam.
All right, Sam Shihab.
Brian Burke.
And we're here going to be talking about an interesting topic, preservation of your green card and avoiding revocation of the green card. I think is an important topic and one that I like to talk about because it's...
Well, we're talking lately to a lot of people who are just on the cusp of getting their green card, just right out of reach. And
the moment they get their green card, they just say, okay, I'm done, and turn it off. They've been exhausted through the process.
A 10 to 15 year process for
I don't blame them, right?
Yeah.
So there's a little bit more of information that we need to work on. So we're going to go through a quick PowerPoint presentation and then break it out. I know there's a lot of questions that were sent before the session, or a few questions, not a lot. We do want to get to them and answer each and every question, related and not related, as we go through this presentation. But let's go through the PowerPoint presentation and see if we can get it going.
I think that's a good idea. We shall turn on our PowerPoint presentation. Turn that off, and there we are.
All right.
Okay, let's get to it. Shall I begin?
Please.
Okay. So, we're talking about getting your green card. Worth talking about, your rights and responsibilities initially. You get a green card, you have the right to live wherever you want in the United States indefinitely, work for whomever you want. You're protected by the laws of the United States, and you can, additional benefit is you can start petitioning for certain family members, get them visas to come to the United States.
So you got responsibilities as a permanent resident. You have to obey the law of the U.S., pay your taxes, register with the Selective Service, which is automatically done when you file your I-485, and do not do anything that will cause you to lose your LPR, legal permanent residency status.
That's kind of what we're really talking about here. There are criminal crimes and other offenses that are grounds for inadmissibility or removal from the United States.
So in English, reasons to lose your green card.
Yeah. These things are probably, the average person out there probably knows that most of these are a problem for immigration. So we'll run through them real quick and talk about what's the big lesson to learn. So there's drug offenses. Any offense relating to a controlled substance, with some minor exceptions relating to marijuana.
Let's pause for a second and talk about that, I think, for 1 second. If you are in a state that allows, for example, certain use of marijuana, the federal government is not on board yet.
Yeah.
So you need to look at the federal law and at the state statute. Back to you.
Yeah, we counsel people on that a fair amount, actually, more than I ever thought we would.
Yes.
Crimes involving moral turpitude. These are, it's a fancy word for saying for just bad crimes with evil intent, get you into trouble.
Like theft.
Yeah.
Embezzlement.
Yeah.
Things that have dishonesty in them. Okay.
False claim to U.S. citizenship is a good one. Voting unlawfully. Another one, an interesting one at least, is domestic violence.
It's a huge one on domestic violence, and it is the federal domestic violence statute that is relevant. And we see that a lot, and it's shockingly that a domestic violence conviction can lead to loss of green card. It is pattern of behavior when one intimate partner threatens or abuses the other. Physical harm is one of them. Forced sexual relationships. Emotional manipulation, that one does not require any touching. Economic or immigration-related threats, notice here, does not require any touching. Stalking also does not require any touching. All these can be considered domestic violence crimes. And one thing that you must understand, in domestic violence crimes, it is not the court conviction that can get you in trouble, is admitting to it is sufficient in certain contexts. So it is highly technical, but I just want you to understand domestic violence, as defined by the federal government, is a removable offense, and you can lose your green card.
Yeah. Really, everybody out there probably knows if you're not a citizen, just don't do crime, don't commit crimes. Nobody's planning on doing it, but sometimes you fall in that situation. And the best general advice there is get a good immigration lawyer. The big challenge of any dealing with a criminal case is what might be a good deal in a criminal matter may not be a good deal for immigration purposes. You could get yourself pled down to something that is a crime involving moral turpitude and cause trouble for yourself.
I have done a lot of these cases throughout the years, and I can tell you the most important aspect of dealing with and correcting these issues is the attorney that you represent. There are a lot of, I think this is the next slide, right? No, not really on this slide. There are a lot of great criminal lawyers who are extremely popular, and they are very well known in the community, and they have a very shallow knowledge of immigration law, and they're too proud to admit it, and they can go walk down the court with you and plea bargain a deal that's completely disastrous for you. If your criminal lawyer does not engage an experienced immigration lawyer to understand what to plead down to, he is going to get you in trouble. So if there's one thing to learn, if you find yourself in criminal hot water, you got to have a very competent immigration lawyer with you. And a lot of time we choose the criminal lawyer to help out in the situation, and we control the scope of the case. I had a case one time that went for 5 years and resolved positively because we were involved from day one. So the immigration attorney is an incredibly important element in trying to navigate this world for you if you find yourself in trouble.
Yeah. We talked about the crime stuff, and there's a general issue of fraud and misrepresentation in green card applications. You essentially, it's an immigration offense to give fraudulent documents, make inaccurate statements, and what can it do to your green card? They can undo it. A process called rescission. Like any other USCIS process, they can come out and issue you a notice of intent to revoke on your green card.
To rescind.
Yeah, to rescind, or put you in removal proceedings.
And they can do it for up to 5 years after the green card is approved. But after 5 years, they don't have to invoke the rescission. They can invoke removability.
Yeah.
But be that as it may, but here's what you have to understand. When we say misrepresentation, if you put on your form that you're 5'9" and you were a 5'7", that's not a ground to revoke your green card. Misrepresentation, it has to be material. By definition, any fraud or misrepresentation has to be material to the decision-making process.
It would impact the process.
Would impact the result. Without this information, or had this information be clearly presented, the outcome would have been different. But if the information or the incorrect information is not material, then there's no fraud or misrepresentation. But again, engage an immigration attorney if you find yourself in that situation.
Yeah. Really, our number one issue that we want to talk about is, abandoning your permanent residence, which is criminal stuff. You can live a good life, avoid that. Don't be accurate in your immigration applications, avoid fraud and misrepresentation. A lot of people fall into this, in the abandonment trap, and it's too late. So, permanent residents are required to keep their permanent residence in the United States. That means it's a place where you reside. Failure to do so means you abandon your LPR status, and it's just, as the general issue is, your LPR status can, in theory, be questioned at any time. Anytime you're entering the United States, you're not going to come to your house and ask, if you're residing in the United States. But anytime you come to the United States, you can be questioned as to whether or not it's your place of residence, and that's really the issue we're talking about here.
So, first of all, factors considered for determining whether your permanent residency is abandoned. How long you've been abroad. Was there a fixed end date for that travel abroad? What ties do you have to the United States? Job? Do you have a job here in the U.S.? Do you have a job abroad? Is your family in the U.S.? Is your family moved out abroad and you're coming back after a long absence? Do you have property here? Are you keeping your property, or you sold your property and left? And then bank accounts, credit card information, financial information, and the big one is filing your taxes as a non-resident. That's basically admitting, non-resident alien, admitting that you are not in the U.S. That's an automatic, almost, abandonment of your green card.
So the interesting thing, I think, where people really start to misunderstand abandoning permanent residence becomes this. They think there's a 6-month rule. It's they hear that as long as I come back to the United States every 6 months, I can never abandon my LPR status. Total fiction. Well,
so there is no 6 months rule that deals with abandonment directly, as you understand it. Because believe me, everybody comes to me and say, "Well, I haven't been outside the United States for more than 6 months." There is a 6 months in the mix, but it is not a
it's
switch.
not a shield. It's not
an on-off switch.
Yeah, you're not infinitely protected because you stayed outside for less than 6 months. So what's the rule really then?
All right. So generally, you will not be considered to be applying for admission if you're returning within 6 months. Now, this sounds like jumbo mumbo. What does it really mean?
Jumbo mumbo sans?
Yeah.
Mumbo jumbo.
Mumbo jumbo.
Of course.
Yeah. For me, the jumbo mumbo is even worse. But what does it mean applying for admission? It means that there are certain grounds of inadmissibility that they can bring up if you entered after 6 months that they cannot bring up if you enter the United States with a departure of less than 6 months. The two most notable ones are health-related grounds. You could be inadmissible because of certain health-related problems that you have had. They can bring that up. They can bring up admissibility for financial reasons.
Public charge.
Receiving government assistance, for example. Whereas if you've left the U.S. and returned in less than 6 months, they cannot bring those up. That's the only really critical difference between less than 6 months and after 6 months, is how you are treated legally coming into the U.S. But other than that, your abandonment is a totality of the circumstances.
Yeah. Goes back to what we said at the very beginning. At any time, you can be challenged upon your LPR status. So other half of that is 180 days up to a year. It's again, you're applying for admission, like you said. You're subjecting yourself to more scrutiny beyond 6 months, and there you go. Your right to enter the United States can really be questioned more.
Correct. But in general, as everybody understands, and that's where the misconception is, the customs usually really don't get excited unless somebody's been outside the United States for more than 1 year. But less than 1 year, they kind of talk to you and say, don't do this, and we're concerned, whatever.
Well, the one that worries me is a classic scenario of somebody who has effectively abandoned their LPR status and is, thinks they can come back every 6 months, and I've beaten it. I live outside the United States. But
it doesn't work.
It doesn't work.
Let's talk about more than 1 year.
Yes.
And then we'll elaborate.
So that's you.
Okay. So a little bit more on the more than 1 year. So the regulation required that your green card has really been invalidated. Doesn't mean your permanent residency is stopped, but the green card to be able to travel back to the United States has been invalidated. And your permanent residency really is in question.
Yeah, you're challenged on it again, and
Yes.
these are kind of a repeat of the issues here. What do they look at? Short period of time. If they consider your business abroad, but you're kind of in a serious area if you're beyond 1 year.
Right. But it has to be closely analyzed, and they look at the totality of the circumstances. And there's really two paths to handle.
Yeah, I want to make sure go ahead.
There's two paths. Is that the next slide or this slide?
Oh, I think the challenging, you got to raise the issue if it ever comes up.
Why don't you go ahead?
Okay.
So how to avoid the issues? First of all, you have to do a reentry permit. It's a great idea. You can apply before you leave the U.S. And it gives you the ability to re-enter the United States for up to 2 years. You can be still questioned on abandonment of legal permanent residence, but at least the duration question is off the table, that you've been outside the United States for 1.5 years. But other abandonment evidence are not off the table. For example, if you get a re-entry permit and sell your house, close your bank account, and have this big see you later party.
Congratulations, you spent your money on a re-entry permit for nothing.
For nothing, because you really have provided evidence of abandonment. But if you haven't done any of that and you stayed outside the United States for 1.5 years, so the question of duration is off the table for evaluating whether or not Europe abandoned it. So a re-entry permit is an excellent solution. Obviously, the ultimate one is the U.S. citizenship application. You file an application, you get a U.S. citizen, you become a citizen, and therefore you can live outside the United States for 25 years, and nobody can question your citizenship.
We see that happen occasionally.
And should you fall in an unfortunate situation in which you're charged with domestic violence and even convicted, God forbid, then it does not affect your U.S. citizenship. Or if you have made an error in judgment and were convicted of a crime, it will not affect your U.S. citizenship. So that's an overview quickly. And here's the question I have for you. So somebody's leaving the U.S. And writes this amazing long letter to his friend saying, I know I lived in this country for 6 years. I've had a great time, but time for me to move on. I'm leaving the U.S. permanently. I have no intention of coming back to the U.S. And and then sells his property, never sends this letter. That letter is on his computer, sitting on his computer that he typed it up.
I like to, I'm already thinking about this, Sam. I'm thinking you're just sounding like the U.S. government hasn't seen that letter that's never sent on your computer.
It has never, and then you're on your laptop, and then the officer opens your laptop and say, I need access to your password, which you give your access to your password, and then here comes the letter right in front of them. Has this person abandoned his permanent residency?
I would,
yes or no?
Yes.
He has
intent is in the mind. It's not. See. Here's where I'm splitting hairs, and I'm an expert in that. Intent is in the mind, not on the computer screen. So you might have a leg to stand on.
You have to. The only thing that you can.
I wrote that letter as a joke.
No, I didn't write this letter.
Oh yeah.
Somebody had access.
Oh, okay.
They had a joke on me. Of course, we're not going to lie. But let's assume you're able to prove that somebody else put that letter on your computer. You can definitely survive.
Yeah.
Right.
Intent is in the mind.
Yes, but clearly it's a problem.
A great big red flashing factor against them fighting favorably for you.
Right. The other scenario is you left the country and you had a major litigation that required your attendance in your home country that involved a lot of money and land, and you ended up taking a job with your employer here in the U.S. but worked for them remotely. Mm-hmm. You had a house. Maybe you sold your house, let's assume, but you threw your car in a garage because you like your car and didn't want to sell it, and you had a bank account, and you filed your taxes as a permanent resident. Which is very different because very expensive. A non-resident alien gets a huge deduction if you're abroad. Has this person abandoned his permanent residency?
Arguably, no.
Even though he's outside the United States for over a year and a half.
They can do it. I just did a case like that somebody applying for a returning resident visa, a spouse of a citizen left with their spouse to do some
foreign country.
Foreign country to work for a U.S. company. And well, as far as I know, they're just waiting on the visa to come in. Just happened approved a couple weeks ago.
Right.
Yeah, there are some exceptions out there. I mean, but don't think about it first. Don't find yourself in that territory. Don't bank on.
So, what documentation would you bring with you when you're traveling? Let's just say you find yourself in a situation where you're outside the country for some time. What documentation you want to have with you? Kind of a secure little folder of documents that you can show in the event there's a question. I'll start with one. You have a property, the warranty deed on that property.
Oh yeah, that's the one I wanted to take. But yeah, that's a good one. Yeah.
What's yours?
Oh, that was the one I wanted. I mean.
All right, I'll give you that one. I'll do another one.
Okay.
You have a mortgage document, the financial. And showing that you've been paying on it.
You know what? I want to see.
Huge.
I want to. This is an easy one. I want to see the birth certificates for your U.S. citizen children, and a nice picture of your family sitting there in your house waiting for them. All your, that.
But you're changing the facts.
Yeah.
The kids are coming.
The kids are with you.
The kids are coming with
Okay.
him. He's not going to travel without the kids. That's an easy one. You made an easy case.
I want your tax returns. You know,
Yes.
don't if you don't file them right. If you don't file indicating
bank
you know,
accounts.
you know, bank accounts.
Bank accounts, right? Bring your bank app showing, right?
A nice amount of money. Yeah.
Driver's license.
Sure,
Valid address.
sure.
Valid driver's license.
Yeah.
It doesn't hurt.
Yeah.
Voting record.
Yeah.
That you're updating your voting record, right?
Yeah.
What else?
We talked about accounts. It's job, employment, residence.
Employment
accounts.
is big. Yeah, your employment, right?
Yeah, if you've been, I mean, the scenario I was dealing with for the returning resident, it's employed by a U.S. company. A U.S. company sends you abroad.
So I'm changing the facts.
Yeah.
So he's working for a foreign company.
Foreign company? Well, that's something little way. I mean, all
just don't include it in the packet, right? Include the stuff that are favorable to you and present your case like a lawyer. You don't have to tell them I'm employed for a U.S. company. All what you have to do is, I am absent for a short period of time. I'm back. Here's my property. Here's my bank account. Here's my tax return. The big one is the tax returns. You file your tax returns as a non-resident alien, even if you have property in the U.S., you're done. I think you have a big problem.
Yeah, I mean, I don't know what I was going to say there.
Other documents I would present is any communications and letters with friends showing intent. Can't wait to see you. My absence has been too long. I would definitely show those as well.
Yeah, and it's all the totality of the circumstances.
So back to the fraud and misrepresentation. USCIS can go back and reopen any green card approval for up to 5 years through a rescission process and give you a notice of rescission. I'm sorry, and we need to go back and talk about what do you experience, back to abandonment. This is an important topic that I almost overlooked. When you arrive
this is the one I wanted. Yeah, okay.
What is it? I didn't even say it.
You are entitled to, if they say, I'm sorry, you've abandoned your permanent residence, you're toast, you're entitled to a hearing on the issue. That's what you're getting at?
Yes.
Yeah.
So a lot of times, and I've seen it happen, the office wants to close this case quickly. So what do they hand in you? A abandonment of your permanent residency form. They say, you can go back, we can get you back on the next flight, you won't have any problem, just sign right here, and then you can leave. Don't sign right here. I know it's intimidating, but if you are a permanent resident, you are entitled to challenge. You have 30 days from the time they say we believe you have abandoned your residency. You have 30 days to challenge it. You want to challenge it on the spot and say, I'm challenging it. I want a judge to hear me. They are required by law to admit you, parole you in the U.S. You have not lost your permanent residency until a judge hears you, and you get to hire a lawyer in the U.S. You get to maintain a job in the U.S., work, so you can afford to defend yourself. Don't fall into these situation where they say, what you have to do is to sign this piece of paper that you've lost your green card. We can get you back on the flight tomorrow, and you'll be just fine. And don't do that.
Yeah.
Fight it. Just say, I have a right to a judge, to a hearing. I want to be admitted to the U.S. so I can have a hearing on the question of abandonment. And the government has the burden to prove that you've abandoned your permanent residency. It's not your burden. It's their burden. They must come in and they must ask the question and make the presentation and convince a judge that you have abandoned your permanent residency. Now, I wouldn't do that if, in fact, you've abandoned your permanent residency.
Intents all in the brain.
You've sold your property. You've been gone for 5 years. You had no contact with the U.S. and you just fly in and say, I want to see a judge. Okay, well, fine, but you're going to lose this case.
Or you can, you can also fight this issue from abroad. Again, returning residence visas.
All right, so I have questions here. I'm going to have a couple of things to talk about the criminal background for a moment. I think the big deal about, and we've talked about that, the big deal about number one, here's a fact I want to share with you. The number one criminal problem we see is domestic violence, because we move from one set of culture from our country to another set of culture and expectation in this country. Many of the expectations and the foundation, the relationship foundation, are the same. Some are different. Some people come here and they feel that they're still in a world in which they can be a little bit more dominating in their relationship, and that's not the case in this country. And then they find themselves in domestic violence problem. And even if the spouse, the other spouse, wanted to walk away from this, sometimes it's very difficult to walk away from it. And if there is a admission as to the elements of the domestic violence, not a court ruling, an admission to the element. I see marks on your spouse's hand. Did you hit her? Yes. Were you defending yourself? No. Why did you do that? I'm sorry, I made a mistake, officer. You have just admitted to the element of domestic violence. You are now, as of that moment, removable from the U.S. I don't care what the judge says on this case. Even if you convince the court to dismiss this case, if the record shows that you've made these admissions, that is called conviction for immigration law purposes. You don't need a court ruling to be vulnerable to this attack. So very important is to not say anything, hire an immigration lawyer and a criminal lawyer.
I want to add, we're talking about all this in the context of preserving your green card, issues of admissibility and removability. But ultimately, these are definitely relevant to those out there who have not gotten their green card. I mean, these requirements are still upon them.
Thank you for bringing that up. This is an excellent point. We've dealt with those issues with people on H-1Bs.
Yeah. I mean, we deal with, if we have somebody with a criminal issue applying for a green card, they come to us and say, okay, I didn't think this day would ever get here. It's my time to apply for a green card.
Even H-1B visas, we get RFEs on criminal background.
Yeah. And you can get advice on that and figure out whether it's going to be a problem.
Is DUI a removable offense?
No.
But
it can be considered a crime involving moral turpitude and admissibility.
So I think there has been some court cases that says second DUI in certain states that rise to an aggravated offense, or a DUI. There's another ruling that says a DUI that involved bodily injury to others can be. So this is a big one.
Yeah.
So let's go and take some questions.
Yeah, we should add that, I think there were some questions that got entered online before we started the stream, and I don't see them showing up here.
Old one. So if there's questions you have posted prior to the beginning of the stream and not showing up here, please post them, and I will make sure that we will get to all of them today. I apologize. I think there has been some glitches in our YouTube account. That has gone down and up a couple times, and they may have affected it. But we're streaming on two YouTube channels and 2 Facebook channels to give everybody multiple options. So if you don't see your question, or just post it again, and we're going to answer it for you. All right.
Anything's fair game. Obviously, a lot of people have questions about adjustment status right now. So pending cases.
All right, sounds good. So let's go to from the top down.
Sure, top down.
So I see 1737. So that one here. Let's go here.
Oh, that's the.
All right.
That's the default thing.
Yeah. Here we go. You're more than welcome, Venkat. It's our pleasure.
Oh, there we go. Here comes Venkat's question.
All right.
So first 2 quarters, USCIS approval I-485 data was released last week. Very discouraging. What are your thoughts on green card issuance for fiscal year 21 last 2 quarters? Can we expect 100K wastage?
Well, I think it has been said time and time again that USCIS is not going to get to all those cases. And that has been a very frustrating thing for everybody. Just file your adjustments. I mean, these problems are bigger than us, bigger than you and me. It requires some serious lobbying. It's a COVID year. It's a 1 in 100 year situation.
I mean, my initial thought is, I wonder if heads are going to roll in the government over that. But also, they have a fantastic excuse.
Well, we've come out a very restrictive government system on immigration. I mean, you know, they were more restrictive in the prior administration. They're less restrictive now, and the transition is slow. So frustrating, disappointing, I agree, but there's not much we can do about it.
We got more questions from Venkat here. So my priority date is September 2014, filed I-45 and EB2 to EB3 downgrade amendment, interesting, and approved last week in premium. Can I expect that my priority date is current in the first quarter of fiscal year 2022?
In the EB3, current in the first quarter of 2022. There has been people saying that it may be current before that, earlier than that for EB3. They're saying that EB3 can become 100% current for India before the end, and that's the most optimistic by end of this year.
Yeah, October.
Yeah. So
I suppose that's yeah.
First quarter fiscal year. That's earlier than that.
Yeah. Well, maybe that means first of the government fiscal year, as in October. So yeah.
Okay.
Yeah.
So yes, by October, yes.
We can't. I guess we can't read minds, but soon.
It's pretty good. Yes.
Yeah.
Can my employer file another new I-140 for EB2 based on old perm diversification?
Okay, so this is somebody who actually had an amended I-140. It sounds like.
Okay, so this is Venkat again.
Yeah.
So he's saying, okay, so based on the prior question, you're saying that you have because you filed an amendment. Now he's trying to reestablish the old EB2. The answer is yes.
Yeah. To bring everybody up to speed, there's a big controversy in October. Basically. Do you file your downgrades as amendments, or do you just call it a new I-140 filing? And the collective wisdom, and it's borne fruit because we're seeing approvals, is you don't have to abandon your old EB2 I-140 and amend it, wipe it out, replace it with EB3. You can file just another I-140 based upon your old labor certification, and then you have an EB2 and an EB3.
But again, I don't want to beat on the dead horse. But again, check the Child Status Protection Act impact.
Yeah.
If you don't have kids are in the age of 16, 17 or so, if you have younger kids like 6 or 7 or 8 years old, you don't have there's no issue. But if you have kids that are close to aging out, that need to be looked at carefully because that impacts it.
Aging out occurs at 21 years of age. If your kids get beyond 21 years of age, they're no longer considered your kids in the eyes of immigration law.
Well, they would not be considered children.
Children. There's a very. I won't get into the technical. I have to go back and read these every time. There's.
If you're unmarried under 21, you're a child. If you're married,
that means you can integrate with your parents through your employment-based petition.
So, Child Status Protection Act plays into it. Check that out and see the impact. All right, Puneet, let's talk about Puneet. Go ahead, Brian.
Sure. My I-45 has been applied on October 27th, 2020, and I-140 is also approved using premium processing on April 1st, 2021. And I have EAD/AP cards in hand with 1 year validity.
That's great.
Yeah, it sounds like your next. I don't see where the problem is, but maybe we'll get to the next question.
Yeah.
The 180-day waiting period from I-45 receipt date is also complete.
Yes.
I'd like to change my employer on August 1st, 2021.
Okay, so you need to, you have 180 days. You can move your green card with you, no problem. I don't see an issue with changing employers. Make sure that the job classification that you're going to is same or similar to the job classification in the labor certification. So you need a copy of that labor certification. You need that job description. Mm-hmm. Make sure that the employer you're going to is willing to issue sign off on Supplement J, which will attest the job description, will list the job description and attest to it before you make the move.
So there's a question, can my employer withdraw the approved I-140? Because the 180-day is not complete since the I-140 approval.
So are you telling me that the I-140 is not the I-140 is not complete?
No, it's approved, but 180 days have not elapsed since the I-140 approval.
Then I would definitely wait for the 180 days.
Yeah, essentially, your I-140 goes kaput.
So I would wait for 180 days on both before I make a move. So the answer is yes. That's a good point.
And the end of the I have changed my employer. If so, and I've changed my or well, happened to be pending I-45 EAD / AP.
So if you change your employer, you already what would happen to my pending I-45 EAD and advanced parole? So is the I-140 approved in that case?
Yeah, that's yeah.
So there's no problem if the employer hasn't withdrawn.
Yeah.
But if the employer withdrew,
you will lack a basis for your. If they withdraw within 180 days, you lack a basis for your I-45, and that's a potential problem.
Right.
Yeah.
So that could be a potential problem, Praneet, if the I-140 has not been going on for 180 days.
Yeah.
But since I got your name, Praneet, I'm going to go ahead and double check those. Those are highly technical questions. I definitely want to double check if there's an avenue out for you. Send me an email. Can we go back to the caption where my email address, which is the second tab? So we can go to the email and write down the email, contact@immigrationvisaattorney.com. Send me an email. I will get you an answer specifically just in the interest to give you a good advice, because I don't want you to I want to get all the details on your case.
Yeah.
All right, perfect.
We go onward.
Hi, I-140 downgrade pending since October 2020. You and many other people. Priority date is November 2013. Okay. Do you feel it's a good option to upgrade to premium processing I-140 processing since dates are moving fast? All right, so I'm saying there's no Child Status Protection Act problems. So take that one out. November 2013.
That's either current in EB3 or very close to current on terms of final action dates.
I think January, isn't it?
Is it January?
Yeah.
Here's how I view this.
See if we can look it up.
Ultimately, your I-140 has to be approved in order for your adjustment of status to be approved.
Yeah.
And that's a barrier. Here's what happens. Here's how you get your green card. Your I-140 is approved and your priority date is current. If your priority date's current and your I-140 is not approved, that's when you start thinking, gee, that's what's in the way of me getting a green card.
Well, another way we're looking at it, filed in October, now it's June 2021. So the government had 7-8 months to find the permanent labor certification. There are no Child Status Protection Act problem. I don't see a problem with upgrading to premium processing.
Yeah, service inquiries are, at that point, you're probably on normal processing times. You might be able to put in a service inquiry, now that they're responding to those very well lately.
Yes.
There we are. So I've applied, and this is from Raj, I've applied EB2 to EB3 downgrade in October 2020. No approval for I-140 yet. Here it is. Should I go for premium or wait for regular?
Kids, yes. My brother did get current. Yeah, absolutely. Go for premium processing if your employer supports it. Now, some employers, and we don't speak to that, some employers have a policy against upgrading to premium processing. They're worried about loss of employment. There's a lot of employees, especially companies that has dependency on H-1B workers.
Yeah.
And when they filed the I-140 downgrade in large number, they are worried about premium processing upgrading in large number and a loss of employees in large number. Mm-hmm. So there are certain companies with certain policies that do not support premium processing. That's a company policy, nothing you can do about it. But talking about the law, if your company supports it, sure.
Yeah.
Do it.
Yeah. I'm always Mr. Silver Lining. They will get to your I-140 eventually, regardless. I can't just let it sit there forever.
Right, but if it's approved and the priority date becomes current,
you have no barriers, but
yeah,
government speed on your I-45 case.
And you throw in your medical when you do premium processing upgrade, and you throw in an updated company letter, and have your attorney review all the documents. You give them all kind of goodies that they want, extra pictures. They open the file. I-140 is approved. There's visas available. Boom, green card is issued. Why not?
Well, this is just I think we kind of answered this earlier. I have a question regarding family-based green card applications and wasn't able to get to it. How do I contact you?
Okay, so we'll repeat. Contact@immigrationvisaattorney.com. Will get to me, and we will do the best to help you out.
Yeah, family-based stuff is all sorts of fun. Here we are.
All right. This is yours, Brian.
Okay, this is from Vishnu. Previous employer filed an I-45 via downgrade. The I-140 is still pending approval. Got receipts and biometrics. Pretty common. No EAD, AP approval yet. Priority date May 2011. The new employer filed perm and I-140 EB3. Both are approved. What are my options now? This is a good meaty question, I think. So,
go ahead and take it, Brian. I'm gonna look at the.
So you have two I-140 approvals from different employers. Both of them are approved. So you have a pending adjustment from the old employer. You can leave that be. You can file a new adjustment of status, based upon the new I-140 approval from your new employer, and that just leaves the other one alone, and the other adjustment of status can essentially erase it. There's a process called interfiling, essentially transferring your adjustment of status from one I-140 to another. You do that by essentially, talk to an attorney about it, but sending a polite letter from USCIS explaining, I have a pending adjustment of status. It was filed against I-140A. I would like to move that adjustment of status to I-140B. There you go. Sam, I know I'm missing an option here. What am I missing?
I think you've covered it. The key is that there is bona fide offer of employment from both, and you're willing to accept.
Yeah, I think. I guess there's a question of was that I-140, the new I-140, necessary? There might have been portability provisions, AC-21 portability.
Supplement J.
Yeah, essentially, you might have gotten to the point where, if we were talking earlier about,
you could have used Supplement J.
Yeah.
If 180 days have passed.
Yeah.
But I think having two adjustment status pending is the Cadillac ride. I mean, for me, it's the best scenario possible.
The only problem with two adjustment of status pending in this case is, do you have any intent to join that prior employer?
Yeah, you have every intent to join the prior employer if the green card is approved first.
That's it. As long as everybody's on board for that, as long as the employer is still down for that.
And sure. you gotta start working for them for a reasonable period of time. We got an email the other day, and I get them frequently. Just got my green card yesterday. Thank you, Sam. Thank you, Brian, for working on it. I'm just going to tender my resignation tomorrow. And that's a problem, especially when you go apply for citizenship. They're going to go look into that. They look into these things. So you got to work. The law says you must work for a reasonable period of time.
Yeah, the whole green card process is premised on a handshake between you and your employer saying, when you become a permanent resident, you're going to work for us on a permanent, indefinite basis. And it doesn't reflect well upon anybody if as soon as you get that green card in your hand, you're out the door. What was the whole point of the process? What is everything you swore and attested to?
A week later, you quit your job and you open a restaurant. That's a bigger problem. I mean, because you're not working in your field.
Yeah,
that's a concern. When you apply for citizenship, say, wow, you're a successful businessman and you own all these restaurants. But you came in on an IT application and you didn't even work for your employer for 2 months.
It kind of goes back to what we were talking about towards the beginning of this hour, fraud or misrepresentation.
What's reasonable period of time?
6 months? More?
Not less than 6 months.
Yeah.
And I think 6 months, 180 days, I think you enter the reasonable realm, because the I-485 allows you to transfer after 180 days. So to me, the 180 days is a good, reasonable period of time. I mean, you cross 1 year, you're definitely. So more than 180 days for sure.
Well, I mean, I got to say, though, it's about, it's the intention in your brain, though. You can't be out there planning to, the whole premise of your green card process is you're going to join this employer on a.
It's not a permanent. It's employment at will.
Indefinite. Yes, this is true. You're allowed. Your circumstances can change.
You intend to work for the employer for a reasonable period of time.
Yeah.
You have no intent. You're not owned by the employer. The employer doesn't 100% own
agree.
You, okay, and it's an employment at will. Okay, this employer can terminate you anytime. You can terminate the employment anytime. But you get a green card from this employer, you must manifest an intent to work for a reasonable period of time.
They don't own you, but
What is a reasonable period of time? More than 180 days. Is 181 days a reasonable period of time? I'd say you can make a good argument. 181 days.
I will agree. Yeah, it's not black and white, but you can make a heck of a better argument.
Do you make a better one at 10 months? Of course you can.
Yeah.
Do you make a substantially strong one at 1.5 years? Absolutely.
Yeah.
Are you in trouble 2 months? Yes.
Yeah.
All right. Next question.
Sometimes circumstances change, though. Sometimes you can't. Sometimes you got to deal with the hand you're dealt too.
Also, if you're let go, it's not your fault.
Yeah.
It's not your fault.
Yeah. You can't really lose sleep on that, because what could you have done?
Yeah,
Yeah.
absolutely. And the other one, which a lot of people don't talk about anymore, but was a big deal back in the, when they started these portability of I-485. After 180 days, not only can you go work for another employer, you can self-employ.
Yeah.
You can work for yourself. And we've done it successfully. We've had a husband and wife. The wife opened, and both were architects. As a matter of fact, their architecture firm until today, and this case is almost 14 years old, very successful until today, and they work together, until now. But the spouse on an EAD opened an architecture firm. The principal beneficiary, which is, as a matter of fact, both had green card pending, so we chose which one to do. So the spouse, one of the spouses ended up opening the company. The other spouse worked for her. And we filed for I-485 portability to this new company that's owned by the spouse and was approved. So that's definitely an option.
It looks like we have more of a family-based question here.
All right. Given 18 months extension of I-751,
removal of when you file removal conditions,
COVID that expires in November this year, will I expect to get interviewed before then? And if not, will they have to further extend? They will probably, I wouldn't expect to be interviewed. They will further extend, and they've done that even before COVID.
Occasionally they shoot out a policy that says, and I'm pretty sure they have to issue a new notice that says
your green card is hereby extended for another year.
Yeah, the backlogs on I-751 removal of condition cases have been a problem for a while, but they're not going to leave you hanging out to dry.
You will get an extension.
Well, yeah, and the worst case scenario is you can go to the local USCIS office if you realize, geez, this notice is running out of time, and they're going to accommodate you, give you a stamp in your passport, that sort of thing too.
But normally you'll get or start issuing calling them like 60 days before the extension. And ask what's going on, where's my interview, where's my approval, or where is my extension to get things rolling. Yep, good question. Suppose I don't get a green card before the EAD advanced probability period. Okay, you don't. Suppose I do not get a green card before the EAD advanced probability. Okay, and I have already changed my employer after 180 days. Okay. Plus I-485 pending. Can an employee apply for employment other than renewal? Yes.
Well, yeah, I'm not quite sure I understand the first half. But the bottom line is the EAD and AP aren't tied to your employee. And
that's why I had no problem saying yes.
Yeah.
The employment application is tied to the pending I-485, regardless of the circumstance.
It's your application personally.
Yes. Yeah. So yes, you can apply, absolutely, 100%.
See what we got here. So EB3 priority date 2012, applied for adjustment of status in October 2020, did not receive EAD, received RFE for medicals in April, didn't submit the medical when applying for adjustment status, pretty common, perfectly fine. What's the next step? Receiving an interview appointment, how long can it take? So, we're entering in a crazy world where I'm talking to a lot of people lately for whom it's looking likely that they're never going to get their EAD advanced parole, and instead they're just going to get a green card. And
that's very normal.
Yeah, it used to be a.
It used to happen in the family context a lot too.
Yeah, I used to think of it as evidence of, wow, they're really moving these adjustments of status very quickly. That's how I used to see that. But now it's more of they're moving these EAD AP so slowly right now, and they're not exactly light speed on adjustments of status right now. But it used to be. Yeah, family cases, you would see it all the time. They approve that adjustment of status before they even get to the EAD AP.
And you may not need an interview. There may not be an interview appointment, maybe just an approval of the green card in the mail.
So that's received RFE for medicals in April. I'd be interested to see where that RFE came from. Those RFEs are sometimes telling about what USCIS is doing on your case. And if it comes from a local USCIS, USCIS has 4 or 5 or 6 or however many now big service centers around the country. And those guys can't issue medicals RFEs. But if it comes from your local city where you live, that means that somebody has your case in front of them in a local field office, and
likely that you're going to get an interview or something.
Yeah, exactly.
So where the RFE came from will give you a clue.
Yeah, where your case is at least.
That's a good point. Yeah.
And eventually, they do. USCIS online tracking is not stellar. If you go to the USCIS website, put in your case number, that'll tell you the status of your case. And a lot of the time they will tell you, I was talking to somebody recently, getting very excited about his case. He said, eligible for interview. I think it's something along first. And then he got interview notice issued, and he's just, bouncing off the walls with happiness, that he's getting there for good reason.
Yep.
So
yep.
You track your case online. They'll give you information about it there.
And what do you expect in an interview? That's a good question that we should have. What do you expect in an interview?
The 30-second version?
Yeah.
So always kind of blows people's mind. They expect to be asked, grilled questions about their life, but really what they do is the USCIS officer takes a copy of your adjustment of status application that they received, and they go to page 1 of it, and go to the first question and go, all right, what's your name? What's your date of birth? What's this? What's that? They really kind of ask you about looking for confirmation of all the information you put in that adjustment of status form, and maybe talk to you about answers they think are interesting.
So I think a few years back, cases were flagged for interview where marriage occurred in less than 1 year of the approval of the green card, even though they're employment-based immigration, but they see a marriage just happened, and they say, oh, well, we want to see if there's a marriage fraud. Is this marriage happening because somebody's passing on a green card? So they want to talk to the wife sometime. They want to say, okay, yeah, all right, show me your marriage document. When do you guys meet? How do you guys, what happened? So it ends up becoming a family-based interview rather than a really employment-based interview. Remember, the local office is all geared to family-based reviews. They're not geared to employment-based. Now, they're getting better at it, but really in terms of like employment and tricky, you're not going to see somebody say, open up the labor certification and say, explain to me your job.
Yeah,
I've never seen that ever, but that's a legitimate question. I would read it and make sure that this is related.
Oh yeah, you're really tapping in on my number one advice for preparing for your green card interview is review your green card application.
Read every page, study it, right? Study it, get the highlights.
But I mean, I don't think I've been to enough interviews, so I don't know how many interviews I've been to. And do I see them asking, about what your job? It's more of like, what do you do? Oh, I'm a computer programmer. Oh, that's cool. Moves on to the does it align with what does it mostly align with what it says what your current employer is on your application?
And they're not going to separate the husband and wife and ask separate questions. Very unlikely.
Yeah, that's more of a family-based.
But even though sometimes the questions are family-based, but what's his favorite food? What side of the chair he sits on? What's his favorite TV show? They've kind of given up on those.
Yeah.
And if you find yourself in those kind of, we probably need to do one of those on interviews. It'll be a lot of fun. Our partner Cheryl Brico did over 600 of those in her lifetime, and we can bring her here and let her talk about it.
She gets to lord that number over me because they used to just do more interviews, and I don't know if I can ever catch up with it.
You'll never catch up with her. She used to do about 8 a day, 9 a day.
I'm jealous.
She comes in.
It's one of my favorite things to do.
But in any event, if you don't know the answer, just say, I don't know. I don't know what her favorite food. I don't know what's his favorite food. I have no idea.
Yeah.
That's okay. Next question.
Okay. This is from Samir.
Fee for renewal, adjustment status, and advanced parole. How soon can I apply for renewal? Can I work after expiration while the renewal is pending? Okay, so fees. We don't talk about fees online.
Well, government filing fees.
There's no government filing.
Yeah, zero.
Yeah, there's no government filing fees. And the history on that, you'll appreciate it, is that there used to be an extremely reasonable adjustment of status filing fees and an extremely reasonable EAD filing fees and a very reasonable advanced parole. It used to be like, I'm going back 15 years, like $300-400. And each one was $150 or $200. So the whole thing was like $400. Then they went out and shot up the numbers, like triple the adjustment. It was like a gouging thing. And everybody was so shocked. They said, okay, but the advanced parole and the EAD are for free. And now I think they probably regret that because now they're so backed up in adjustments and they're doing so many advanced paroles and so many I-765 for free.
Nothing. Yeah.
Yeah, it doesn't make any sense. But anyways, how soon can I apply for renewal adjustment of the EAD and advanced parole?
Well, the rule of thumb is 6 months out. But here's a beef I have right now. Their processing times are longer than that for pretty much any kind of EAD out there right now.
But still 6 months.
Still 6 months. Yeah,
but it's going to get better.
Well,
I think it's going to get better.
For the adjustment categories, there are. This is the sort of thing where you best to send us an email so we can provide you the best information. But there's certain categories of EAD where they allow for extension of your EAD while it's pending, and adjustment.
But most employment-based, no.
Yeah.
And most spouse-based, I think asylum and a few others, and EADs for OPT extension. But for adjustment, very, very few, if any. You got to have the EAD in hand.
Yeah. And rule of thumb: if you don't know what you're doing, make sure you have the EAD in hand.
And for employment-based, there's a forgiveness rule if you find yourself in trouble, but you're not allowed to work while the EAD is pending.
Yeah. Let's see what we got here. Let's try this one right here. It's from Neil. I've downgraded my EB2 to EB3 and received an EAD card, but I-140 is still pending. Can I use my AP meanwhile? Can I use my AP? So, sure. Your AP. Watch what travel right now is. Generally yes.
It's an EAD card, AP, but I-140 is still pending. I use my AP meanwhile. EB3 final date's current. You can use advanced parole anytime since you have an EAD card.
Watch where you're traveling, though. There's so many travel bans in place right now. There's the European Schengen area zone travel ban. There's the India travel ban, and I believe Brazil and Iran are still in effect too. And the general thrust of those is that if you've been in one of those places in the last 15 days, you can't enter the United States.
If the EB2 date's current with approved EB2 I-140, do I still have to file adjustment of status? I guess that's an interfiling question. You could interfile. Well, you really cannot. You can interfile while the EB3 is pending. Yeah. That's allowed. So you can interfile while the EB3 is pending, but good luck chasing that. Or you can file a new adjustment of status, and we've had a whole session on that as option 2. Which one is better? I guess money, security. Which one is more important to you? You're giving up some security with interfiling. You're paying money for adjustment, but you're receiving a receipt notice and you can track it. So you can do either.
Yeah, I mean, you use a term which I like there, chasing. EB2 is moving faster, and I jump over there. I mean, who knows how long
what happened to EB3? It moves faster 3 months from now. We're going to interfile back again. And remember, interfiling is discretionary, and they're not going to tell you whether they accept it or not. And if they're close to approving one, they may say no. So adjustment status is a sure thing. Interfiling is popular. It's cheap. It's quick. You mail it. But what happens after you mail it, God knows.
Yeah, that's a...
Yep.
Hey, it was a good question. It's we said EB3 will become current. Can you elaborate on more details? Well,
it's just
speculation.
Total speculation, projection, no knowledge. There is no knowledge I have or any attorney that has as to what will happen. And if you go in and spend hours on the website, on the internet, looking for projections, and there's all kind of resources. But there is strong evidence that the embassies will continue to struggle with COVID. The world has not recovered. The big users, country users of the green cards, whether it's Philippines for family-based or whether Mexico for family-based, are just slow in granting green cards, and they're moving them to employment-based. So there's a big optimism on that.
Well, I'm going to turn off this question for a second because I have somebody sent me one via emails and they wanted to send it to me beforehand. It's a really great one. It's does the I-45 application provide an applicant with the right to stay legally in the U.S. without EAD or any H1/H4 visa while the application is being processed?
The answer is
yes. Just by having a pending adjustment of status, you are allowed to keep on staying in the United States, and that's kind of a realistic thing. No working without a
So I'm
valid.
going to add to that question.
Okay.
What happens if that application is denied?
The adjustment of status
Yeah,
application.
You got a denial, erroneous denial.
Well, you are in some serious trouble. That's for sure. If you
Right.
know
You've lost your right to stay here if you don't have
Yeah.
any other basis.
Yeah.
Now, can you file a motion to reconsider?
Yes, you can.
By filing a motion to reconsider, can you stay in the U.S.?
That's the sort of thing where I'd start pulling out my hair and want to hit the law books before I because
and filing a motion to reconsider may still accrue you can decide to stay.
Yeah.
But you're accruing unlawful presence.
Yeah.
Right. And with the government delays, once you hit 180 days unlawful presence, you're in danger of being unlawful.
Yeah, it's a denied case, so the appeal does not grant you any benefits while it's pending. So yeah, you're dealing with unlawful presence and serious business.
Yes, and also if the appeal is approved, then you're in good shape.
Yes.
It wipes out the unlawful presence, wipes out any overstay because it's basically reinstated and you're in great shape. And therefore, it's always a good idea to maintain a different status. People say, well, I don't want to renew the H-1B. I want to be on I-45 with EAD, advanced parole. And that is not a problem, and that's fine. And most of the time, you're not going to have an issue. But that's not for everybody. Some people will have an issue. There is improper denials, and there's proper denial. There's surprises, There's a lot of great companies out there. Most companies are ethical, honest. The I-140 is fantastic. But there's some companies that they go in and they find that this company's I-140 application should be denied for misrepresentation or financial ability, and then all of a sudden the I-45 falls apart. Not your fault. What fallback do you have? You don't have any.
So I've got a couple more here. So I submitted my medicals in October 2020. How long does it take for medicals to become stale? 2 years once they're submitted to USCIS, but you have to submit them within 60 days of their signature, but that's already taken care of for you. So
2 years.
2 years. You got plenty of time left. Let's
Yes.
hope they don't take advantage of that entire period.
Yes. This will be recorded. I know all of you guys are interested in the green card for good reason, but you got to start focusing in on the green card preservation.
Yeah.
Green card preservation and avoiding revocation. 2 things. If you say, what's the summary? What's a 10-second summary? Watch out for the domestic violence problems. Conviction is not a court order. If you've admitted to the elements, you will be deemed convicted even though without a court order. And the other one is don't assume a long duration absence from the U.S. or short duration absence from the U.S. is the test. The test is the totality of the circumstances.
Yeah. I think I'd want to group those first two. If you have any sort of criminal problem, it's you talk to not only a criminal lawyer but an immigration lawyer.
And if your criminal lawyer says, "I know all these things about immigration law," run. Now, some do know a lot about immigration law, but most don't. And unless they have an immigration attorney in house, or he or she will tell you that, "Oh, I file immigration law and I do immigration law work."
Yeah.
Then you may feel more comfortable, but you 100% need the help of a competent immigration attorney that can guide the criminal lawyer as to what they can plead to and the extent. A lot of time you go into the prosecutor and say, "Mr. Prosecutor, I have an issue with this plea because this is a good kid, had no history with the law before. This is really an embarrassing situation. But if he's found guilty, this person is deportable. And he is a father of 2 U.S. citizen children. But if you take this here, and I know you don't agree a lot of time to provide this kind of relief, but you will save this guy."
Prosecutors have discretion, and
there's one thing that we haven't talked about, which is the diversionary program. And this is getting deep into criminal issues. You think that, and this is why you need an immigration lawyer. So what's a diversionary program? It's a program where you go to the court and say, you know what, we're not gonna take you to jail. We're not gonna get you in trouble. So we have this great program here called diversionary program, where you sign off that you will do community service and all kind of things, and then we're gonna just dismiss the case after 6 months, and there's no conviction on your record. But guess what? A lot of diversion, but not all, a lot of diversionary program have provision in it that you have admitted to the elements of the crime. I hereby admit to the theft. I hereby admit to domestic violence. I've done all these bad things, and I'm sorry. And then they're going to dismiss the case. But that piece of paper is in the record. And if immigration gets a hold of it, you will be subject to deportation.
Oh, how will I get a hold of it, Sam? Well, if you have to, on your adjustment of status forms, you got to disclose, criminal things, even if there is no, even if it was dismissed. And, they ask you, oh, please provide us with a complete record of that case. And
certified court
records, and the court will cough that up, and you'll see all of that stuff in there.
And they can find it on their own. And an expungement and sealing of their state records,
they don't care,
are ineffective for under federal law for immigration law purposes. They are completely ignored. You can seal them all day long. You have to come out with them in detail.
Usually one of those RFEs says, regardless as to whether it is expunged or sealed.
Right. Bring us the record. So I hope this is helpful. And we are going to continue these presentations. What are we going to do next week?
I don't know. Well, next month. So next week is the 5th of July, which is a federal holiday.
So we're going to do it either a day earlier or a day later. We'll figure that out and we'll announce it. And we're going to come out with a fun topic.
Yeah, we're going to be shooting off fireworks.
So we have a list of 5 or 6 topics. If you believe that you're really dying for us to talk about something, I will 100% take your recommendations. Shoot us an email on contact@immigrationvisaattorney.com, and we will listen to your suggestions. But we intend to keep them going, and
it's fun.
And yeah, we're enjoying it. Hopefully you guys are enjoying it. Have a great day.